Good day, students. Today we're going to do Unit 12 to 15. Let us start with Unit 12. In terms of Unit 12, we're going to discuss the issue of mineral rights, water rights, as well as lease rights. Now, let's start with mineral rights. So, for the purpose of the definition of what is a mineral, please go to page 244 to look at the definition of the word minerals in terms of the Mineral and Petroleum Resources Development Act. Now, let's discuss the mineral rights under common law. Under common law, the landowner was also the owner of mineral rights. So basically, he was the mineral rights holder until such minerals have been extracted or separated from the soil. So he was the owner, except where those mineral rights they were reserved for another person, or maybe they were reserved for the state. Now, the mineral rights entitles the holder thereof to enter into to enter upon the land, to prospect is to search for mineral rights, and as well as to mine for minerals. Now, a separate title of mineral rights, it could be severed from the land ownership, meaning that you can have a title deed for your land only, and also have a separate title for mineral rights. So so mineral rights can be like mineral rights title can be transferred from one person to the other by way of what you call notarial session, and also mineral rights, they can be expropriated. Now, in terms of like the situation now, in terms of the Mineral and Petroleum Resources Development Act, is that common law position of the landowner being the owner of the mineral rights, it has been abolished. So now the state is now the custodian. It's not the state is not the owner, but it is the custodian of the petroleum as well as mineral resources in the republic. So in terms of Section 3 of the Act, it says the state is the custodian. Now, the implication again of that Act is that those mineral rights that were held in terms of the previous legislations that were regulating mineral rights, is that those the so-called old order rights, such as the prospecting rights, mining rights, as well as mineral rights, they were now the holders thereof, they were required to convert them into what we call the new order rights. Now, those unused old order mineral rights and mining rights, they've expired after what we call the transitional period. So those unused mineral rights as well as the prospecting rights, they are now vesting in the state. Now, those prospecting rights as well as mining rights, they are now considered as limited real rights. But now to transfer those, or cede those rights from one person to the other, then you will require the consent of the minister that is responsible for minerals. Now, to acquire those rights, they need to apply for prospecting rights as well as mining rights to the relevant Department of Minerals and Department of Mineral Resources and Energy. Please look at page 247. And then, with regard to the water rights, the water use rights, previously they said, like, the position was that the Water Act of 1956 was regulating the water rights as well as the water use. So that 1956 Act, what it did was it retained the common law distinction between what you call private water as well as public water. So meaning that previously you could now own water like privately, but now in terms of the National Water Act of 1998, it did away with the distinction between private as well as public water. So in terms of the new act now, the state is the trustee of all water resources in the country. So so therefore now, to have the water right, we now have to get the consent from the relevant minister. In this case, it's going to be the Minister of Water and Sanitation. Another act that is also dealing with issues of land use as well as rights, as well as I think also the issues of licensing, water licensing, is the Water Service Act of 1997. So if you can also look at page 251 of the State Guide to go to understand the issue of the water rights in the country. Now, let's go to the tenants right. Now, in terms of the tenants right, here we're dealing with the situation where there is a lease agreement that has been entered into between the lessor and the lessee. Now, there is this Roman Dutch law rule, maxim, or doctrine, whatever you're going to call it. But in terms of this rule called it means the lease overrides the sale. So in terms of this rule or doctrine, the lessee acquires the limited real rights against the subsequent purchaser of the land. So what's the meaning is, if ever there is the property was sold to the new owner is now going to be bound by the lease agreement that was entered into by the previous owner as well as the current tenant. Now, this principle it used to apply to lease of houses as well as land, but it's been extended to movable things. So there are several cases that confirm this rule. Go to page 253 of the guide. Now, with regard to leases also, there are two types of leases. There's what we call long lease and short lease, right? Now, depending on whether we're dealing with a long lease or short lease, in terms of to confer limited rights for short lease, they need to be the person need to be in physical control of the premises. Whereas in terms of the long lease, for it to confer limited real rights, they need to be a registration. Now, let's first deal with what we call a long-term lease. So long-term lease or long lease, there we're talking about a lease that is 10 years or more. So previously, like in terms of the Roman Dutch law, a long lease to be considered a real right, it was required to be registered. Now, if that lease was not registered, therefore it was considered a personal right. But once it is registered, it is now being converted to to what we call real right. Now, an unregistered long lease, even though it was not registered, but it was also valid against the successor who took notice of that lease. So even if, again, even if the lessor didn't know the lease, correction. So look, even if the new owner did not know the lease, the lessee was protected for the first 10 years of that lease agreement, provided that he or she is in physical control of the premises. Now, in terms of like in South Africa now, the situation with regard to long leases is now regulated by the act called Formalities in Respect of Lease of Land Act of 1969. So that act is now saying that for a long lease to be valid and also binding on the successor, it must be registered. So, so any lease which is more than 10 years to be binding, it now needs to be registered. So the legislation that is going to be used to register that lease is going to be the Deed Registers Act of 1937. Now here we have another form which is short lease. Now that lease, a lessee who is not in control of the premises will only have what you call a personal right. Now, however, that right is going to be converted into a limited real right when the lessee now takes possession of or occupation of the leased property. Now, the effect of the lessee's real right or the tenant's real right is that that right, because it's going to be a limited real right, it's not going to enjoy preference over mortgagee as well as the servitude holder. So another effect is that the successor cannot disturb the lessee in the exercise of the right in terms of the lease. Also, with regard to the effect thereof is that in applying that doctrine that I talked about, the one of Irhad Furko doctrine, it was held in Vienna by Properties versus Video that the buyer or the successor replaces the seller, and that particular buyer is not going to be bound by all the terms of the lease agreement that has been entered into by the seller as well as the lessee. Now, the new owner will also be entitled to rent. So basically, the buyer now will replace the previous owner, and then he's not going to be converted into the lessor, and then he's going to be bound by that lease agreement that has been entered between the lessee as well as the previous owner. Now, let's move to Unit 13. Unit 13 is dealing with constitutional property law. So here, the most important section in the Constitution is Section 25. So I suggest you look at the definition of the meaning of property in terms of Section 25 in page 260 and 261 of the study guide. Now, in the Constitutional Court case of FNB, the Constitutional Court acknowledged the difficulty in outlining the comprehensive definition of property for the purpose of Section 25. Now, the court held that ownership of corporeal movables and land lie at the heart of the constitutional concept of property, and then they must therefore be afforded the constitutional protection in terms of Section 25. There are other rights that are also protected under Section 25. If you go to page 261, then you will find the list of those rights. And then there are other constitutional cases that also confirm certain rights that are considered to be property, and then that deserve constitutional property. That deserve the constitutional protection. The first one here is the trading license, as well as the personal right to recover money paid for goods delivered in terms of the National Credit Act. So those are new rights that are now recognized and that are afforded constitutional protection. I'm going to deal with two. I'm going to deal with what you call deprivation as well as expropriation. Let's start with deprivation. Deprivation, for the purpose of understanding what deprivation is, please look at the provisions of Section 25 of the Constitution. Now, the deprivation is what you call the exercise of state as police power, meaning that here the state is now regulating the use of private property by restricting certain owners' entitlements, right? So, meaning that in this case, although you own your property, but there are some laws that the state has now imposed for you on how you must now use your property. Now, if ever the state is depriving you the use of that particular property, then the state does not have to pay compensation for that deprivation. Those deprivations, examples thereof is in terms of land use planning, like you have the conditions of title, then there's also developmental as well as environmental conservation legislation. Now, expropriation is what you call the taking away or the acquisition of private property by the state. So the state is taking away the property in the public interest or for public purposes. Now, when you're dealing with expropriation, compensation is always payable. Unlike deprivation is more like the state is just regulating, but with the deprivation, it's taking away of private property. So with deprivation, there is no compensation that is payable, whereas with regard to expropriation, there is compensation that is payable. The compensation is regulated by Section 25, 2 to 3, as well as the Expropriation Act. Now let's go to Unit 14. Unit 14 is what we call the South African land reform. So South African land reform is divided into 3 categories. The first one is redistribution of land. When we think about redistribution of land, we're talking about the process where the land must be made available to people who didn't have land before. So with regard to redistribution of land, there are several legislation that have been passed to make sure that people have access to land. Just to give you an example, we have got Provision of Land and Assistance Act, then we have Special Planning and Land Use Management Act, that is called SPLUMA, and then we have the Land Reform or the Land Tenants Act, as well as the Extension of Security of Tenure Act of 1997. Now, the second category of land reform is what we call land tenure reform. So in terms of this one, the aim of this reform is to recognize and protect those weak rights that like the majority of the people used to have under the apartheid laws. So you find that especially with regard to blacks, there were those apartheid laws that were passed that weakened, like the land rights of black people. So the aim of this land tenure category is to now recognize as well as protect those weak rights. So there are several legislation that have been passed to now deal with issues of strengthening as well as recognizing insecure rights. So we have the upgrading of land Tenure Rights Act of 1991. Then you have the Communal Property Association Act. This act is now dealing with the communal property, on how the communities can form an entity and now be able to acquire, manage, and then to acquire, hold, and manage property as a group. Then you have the interim protection of Informal Land Rights Act of 1996. And then you have we used to have what you call Criminal Land Rights Act of 2004. However, that act, it has been declared unconstitutional in 2010. Now, with the issue of land reform, in order to recognize and protect the insecure rights of some of the people that are occupying land, there are several legislation that have been passed to regulate the process of eviction. Now, there are several legislation that were passed that will now regulate on how you're going to evict different types of people. E.g., you have the Land Reform or the Labor Tenants Act. That act, it's now dealing with how to evict. There is a certain category of people that you call labor tenants. Those are people that are working in a farm. Then instead of being paid as employees, they are given the right to do their own livestock farming as well as grazing in a particular farm. So instead of being paid salary, but they are now allowed to do their own livestock or grazing within the particular farm. So these are Labor Tenants Act is now regulating on how you need to evict those. And then you have another legislation that was passed following Section 26 of the Constitution. Now, those act, there is one that is called Extension of Security Tenure Act. That one is dealing with a situation where people, they have the permission from the landowner or the person in charge. And then you have the one, there's this act called the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act of 1980. That one is dealing with people that are occupying land illegally. Now, the third category of land reform is the land restitution reform. Now, that one, here we're talking about, in simple terms, we're talking about the land claim. So this one is regulating the land restitution process for people or the communities that were the people who were dispossessed of their land, after June 1930. Now, the main legislation that is dealing with land claim, we've got Section 27(5) of the Constitution, as well as the Restitution of Land Rights Act of 1994. Now, initially the cutoff date was 1998, but however, there was an act called Restitution of Land Rights Act of 2014 that extended the cutoff date to 2019. However, that amendment act was declared unconstitutional in the case of the Land Access Movement case. So, yeah. Now let's go to Unit 15. Unit 15 here, we're dealing with additional forms of statutory land use and revision. Here, there are certain legislation that have been passed to now regulate another form of land ownership. I have several acts here. I'm going to try to run through them very quick. The first one is the Sectional Titles Act. The Sectional Titles Act is dealing with what you call sectional titles. In most cases, you see them in what we call security complexes or even block of flats. So there you are having what you call units. So basically, the that act is dealing with the opening of the sectional title scheme, and then talking about like the division of buildings, and then the division of building and the land on which they stand into the section, as well as the common property, as well as the ownership thereof. So this act is talking about how the ownership land holding system in that in those complex or the block of flats, as to who's owning the units, who's owning what we call the common properties. The common properties are your, like the passages, like the lifts, those areas that people are not residing in within, like either the block of flats or in the security complexes, like your roads or so. So the Sectional Titles Act is dealing with that type of ownership. Now you have the share blocks control act. Now, in terms of this act, you have the group of people can now establish what you call a share block company. So in terms of this law, the shareholders of that company, like the company can buy property, and then the shareholders will now have the personal rights to, like they acquire personal rights to use part of the building. So you might find that the company, like the share block company, will buy either, like a block of flats for residential, or maybe like its offices or shops. So if you are a shareholder in that company, once that company buy property, then you already have a personal right to now use certain parts of the property that that share block company has purchased. Now you have another legislation is called the Property Time Sharing Control Act. Now, in terms of that act, it regulates what you call the alienation of time sharing of property time sharing interests. Now, what is happening here is you have a section, an example of these properties where certain people buy property, and then instead they now have the right to occupy that property within a certain period of, like season, e.g. If ever you buy a property, then you find that in terms of their agreement, then you are only allowed to occupy that property from, like let's say this season or this time of the year or so. So when a group of people buy a property, and then and then like those examples, like the examples thereof can be the holiday homes, wherein you buy the holiday home, like as a group, and then you decide in terms of the agreement to say who's going to occupy this property in which time of the year or season. Now this act come into play. Then you have the Housing Development Scheme for Retired Persons Act. This one is simply dealing with the issue of let's call them a retirement village. Right? So that is that act that is dealing with retirement villages. That will be the end of my presentation. Thank you very much.